some time today and go over the GFE and HUD 1. I'm sure it'll be interesting, and just keep you pinned to your chair for the whole next half hour. The PowerPoint has I think 17 or 18 pages. We're not going to go over all of the pages due to the time constraints, but Liz will be operating the PowerPoint, and we'll move through and talk about the things that I think are really what we run across on a pretty regular basis. So if we could go to the next page, can everybody hear me? Okay, well, assuming you can. Yes. Okay, so we'll go ahead and get started with the next slide. And this is the seller paid GFE, seller paid items on the GFE. This particular issue brings up a lot of questions. And so we'll start with this question, and this is kind of a question and answer so you can read it and see if at the time the GFE is issued, it is known that the seller will pay settlement charges typically paid by the borrower. How are those charges disclosed on the GFE? And the thing that I would like to point out to everyone, the GFE is not about how much money your borrower needs to bring to closing. The new GFE is about what charges can be incurred by the borrower regardless of who's paying for them. And that's pretty much how it works. So the answer in this particular question is all charges typically paid by the borrower must be disclosed on the GFE regardless of whether the charges will be paid for by the borrower, the seller, or other parties. And what that basically means is regardless of what your seller has agreed to pay in closing costs on the GFE that we will give the borrower, it will list all the closing costs that the borrower would typically have to pay in a transaction regardless of what the seller or any other third party is paying. So do we have any? Okay, so if we'll go to the next slide, next page, it says, and this is continuing with the GFE, are charges to the seller listed on the GFE. And this is a rather long and complicated answer. I'll read the answer, but I also will try to explain it in layman's terms as much as I possibly can. RESPA requires that only the borrower receive a GFE. The GFE is defined as an estimate of settlement service charges a borrower is likely to incur in connection with the settlement. Charges that typically would be not charged to the borrower, but would be charged to another party, such as the seller, do not have to be included on the GFE. If the borrower typically would incur charges for title services and lender and owner's title insurance, the GFE instructions make it clear that those charges are required to be listed regardless of whether, for example, the contract requires the seller to pay for the service. If there is a question about whether the borrower or seller is to pay for a particular settlement service, the charge for that service should be disclosed on the GFE. That answer right there should answer just about any question you have regarding the GFE going forward. Where things may seem to be clear-cut and precise, they aren't. And as we go through this, I'll point out one area in particular that comes up all the time. But the only charges that you will never see on a GFE are charges that are state or federally regulated to be charged to the seller or a third party. Otherwise, unless it doesn't have such designation, those charges will typically show up on the GFE. So long answer for a short question. So we'll go to the next page, and we'll talk about written list of providers. And I'm not sure if everyone is really clear on what this is, but basically what a written list of providers is, under the new GFE, HUD is requiring the lender to provide a list of providers that can provide settlement services, home warranty, a home inspection, all of those types of services in connection with the purchase of a home. And this is not an endorsement of any particular servicer or provider, but it is required by HUD to be given to the borrower. So we do that, and it's not against HUD regulations to put on your list of providers affiliated businesses, so we do that as well. And we have the providers that we have listed, for example, for attorneys are all agent-owned agent-owned alliances, I'm sorry. And then we obviously have Wally Burbage Allstate listed on there as well. So those are required by HUD, and so we provide that at every application when we provide the GFE. We don't provide the GFE until we have the name, Social Security number, name and Social Security numbers of all the borrowers, a particular property address, a ratified contract, and the documents required by the buyer in order to pre-qualify them. And so typically when we do a pre-qualification, we don't have a address of the property wanting to be purchased, so that is a pre-qualification. Once the contract is ratified, then we have 3 days to issue the GFE, and that's typically when we'll do it. So we go back to the next page, or go to the next page, which would be page 5. There's a few things on here I really want to kind of bring your attention to. Mainly the very first one. Only 2 categories of service providers may be listed. Providers that conduct settlements or closings, and providers of lenders, title insurance, and related services. And then at the bottom part, if we'll get to that, it'll say the service provider was chosen from the written list. One more, I believe. There we go. The service provider that was chosen from the written list would be included charges that cannot increase more than 10%. With the associated estimate fee from the written providers list in the GFE column and the actual fees for that service from the provider in the HUD-1 column. The service performed by providers not chosen from the written list of providers would be listed charges that can change section with associated estimated and actual fees. Now, that's what HUD that's straight out of the HUD FAQ guidance that we get for the new GFE, but let me give you the reality of what that statement really means. When someone chooses a provider on the list that we've provided, and we'll use Weeks as an example, Weeks is one of them on our list. All the charges that we disclose, we have to be within 10% of actually what Weeks Law Firm charges. And if we're not, then we have to make up the difference. That's called an out of tolerance, and we have to cure that. And the way we cure that is we have to pay the difference over the 10%. So obviously we want to be as accurate with these charges as we can possibly be. In addition, when the servicer is provided, when a service is provided from a provider that is not on our written list, those charges can change, but here's the problem that we have discovered with that. While HUD allows for those charges to sit in the charges that can change section, selling those loans on the secondary market have become problematic. So what we have discovered is a lot of times we have to cure those tolerance issues as well. So sometimes that does create a few glitches when it comes to the closing. What we try to do when we have a service provider that we're not familiar with is to get their charges ahead of time so that we can at least disclose them as accurately as possible. But this from time to time will create some problems. Do we have any questions so far? Okay. Well, we'll go to the next page. Let's see. We can. This is one of those pages I would encourage you to take some time to read. I believe there's a link on that we've provided that you can print all of this off. So we're going to basically skip this page and go to the next page. Yes, ma'am. We'll go to what would be page 7. And what we're going to be talking about on page 7 is whether or not the loan originator can include an affiliated business on the written list of settlement service providers. And of course the answer to that is yes. Does the requirement for a written list apply to Block 4, that's title services and title insurance on the GFE? And that would be the next question, and the answer to that is yes as well. So this, while it may seem complicated, really isn't. We just have to make sure that our providers list have all of these providers that supply these services on it. And like I said, in residential mortgages case, we list as many. Well, we list 3 per item, but we list as many of alliances as we can with agent-owned, so that we don't rely on any services outside of agent-owned whatsoever. So we'll go to the next page, and this is a topic that comes up with a lot of questions from time to time, and I do want to make I need to make one quick disclosure here. I am not an attorney, nor am I a licensed attorney to practice law in the state of South Carolina. So what I'm giving you today and what we're talking about is information that I've acquired from HUD over the years and working with this project, and also from our legal counsel and our own internal guidelines as to what we interpret those FAQs from HUD to be. So having said that, we'll move on to changed circumstances. And changed circumstances has probably by itself created more questions than anything. So here we'll start with the question that once a GFE is issued, are there any circumstances which the loan terms can be charged? I'm sorry, I totally screwed that up. Basically, is there anything that can happen that would allow you to change anything? The answer to that is yes. The loan terms or charges can change in the event that there are changed circumstances. I won't go through the whole definition of a changed circumstance, but the short of it is it's an act of God, war, disaster, or other emergency. It can also be information particular to the borrower or the transaction that was relied on to begin with in providing the GFE. So, for example, you provided us an executed agreement. The appraisal's done. It's discovered that the property has either serious issues or will not appraise. So the purchase price is lowered. That is a changed circumstance. So at that point, we have 3 days to issue a new GFE to the borrower. And also information that's supplied to us by the borrower that later on proves to not be correct as far as credit quality, how much money they may have available, employment, all of those things. And of course, last but not least is the boundary issues, flood insurance, or environmental problems. So if for some reason the appraiser is walking around the backyard and finds a oil tank sitting out there that's rusting, well, that's a problem. So these are things that you should look for, but just in case you don't know, any of these things that take place, however, is what's called a changed circumstance. And as a lender, once that changed circumstance occurs and is brought to our attention, we have 3 days to respond to that with a new GFE for the buyer. So we'll go, that pretty much answers all of that. We'll go to the next page. This would be page 9. And in addition, the loan originator is presumed to have relied on the borrower's name, monthly income, property address, an estimated value of the property, the mortgage loan amount sought, and any information contained in any credit report obtained by the originator before providing the GFE. The loan originator cannot base a revision of the GFE on this information unless it is changed or later is found to be inaccurate. So the most common case that you'll see in that is we issued a GFE prematurely, say before we actually had the completed contract, and blocked it in, set the cost, and then we get a information that's different. Once we've taken that step, we've already and have any of this information that's been provided, unless it's found to be inaccurate, we pretty much have to live with it. So again, that's why it's vitally important, and we'll ask every agent involved in the transaction to provide us all the necessary information as soon as possible, so that we can make sure that the charges that we're disclosing to your borrower is true and correct, and the interest rate and the loan program that we're doing, and all of those things. Well, basically the difference of the two GFEs. In the past, the GFE, or good faith estimate that we would do, would really take a particular sales price, then we would break down the individual closing cost, interest rate, term of the loan, and give you a payment, principal, interest, taxes, and insurance. And then the bottom line number would show what the borrower actually needed. And a lot of times these were not guesses, but they were estimates. And as each and every one of you have probably seen in your career, those estimates would turn out to be very different by the time you get to closing most of the time. So in the interest of transparency, what HUD has tried to do is take the GFE and remove the how much down and how much you need to bring to closing part out of it, and have us completely disclose any and all charges that the borrower could possibly have to pay in connection with that particular transaction, regardless of who's agreed to pay what. But what they want to see is, for example, the sellers agreed to pay everything but the down payment. They still want to see what all those costs are, and then on the HUD 1, which we'll kind of briefly go over, all of those credits will be shown on the HUD 1 in the 200 section, and that's where all those come in. So if the closing costs are $3,000, there'll be a $3,000 credit, and that's really the basic difference. It's just disclosing everything.
And I think that's the reason you have the because that's the biggest part of this new HUD.
Correct. I didn't hear all of it. What?
I said the big thing about the new good faith estimate, the reason you're dwelling on it so much is because it's got to match the HUD.
Correct. And what Liz said is the reason why we spend a lot of time dwelling on the GFE is because it's vital that it matches the HUD, and that is correct. What when HUD went through the whole RESPA process and looked at changing the GFE, I was involved in those roundtables, and I can assure you that the GFE we have today was not what was recommended by industry. But that is what we have, and again, you need to look at it from the standpoint of transparency. What charges could your buyer possibly be obligated to in this transaction, regardless of what the contract says? And that's really kind of how you look at it. Page 9 continues to go on and talk about changed circumstances. And we've talked about all of these. The last part of page 9 talks about how when a changed circumstance occurs, what does the loan originator need to do? How much time do they have to do it? And 3 days. 3 days from the time that the changed circumstance takes place, we have 3 business days to get a new GFE out to the borrower. So it's very simple. Well, it's exactly what it would be on a ratified contract when you're first starting. 3 business days. And Sunday is not considered a business day. So if we go to the next point, this is page 10, and this part has probably created more questions than anything. Let's see. Have to move to the next one. Transfer taxes. In a given month, I get probably 24 questions a month about transfer taxes or deed stamps. So again, I'm not an attorney, but I will tell you what I have read in accordance to state law where deed stamps or transfer taxes are concerned. State law does not mandate that the seller pay it. What it does say is that the seller is primarily responsible, with the borrower being secondarily responsible. So HUD interprets that as saying not every single transaction the seller will be paying the deed stamps and or transfer taxes, that there is a possibility that the borrower would have to pay those. And the answer to that is absolutely correct. And we're seeing it more and more, especially with REO properties. The lenders aren't willing to pay the deed stamps. Some of the builders now are getting to the point where they're not willing to pay the deed stamps. We actually, as a lender credit, had to pay the deed stamps for someone in order to keep a builder deal, because the builder was was not willing to pay them, and so the only way we could make our deal different was to pay them. So this is happening more and more and more. The problem is that every originator doesn't want to disclose them, because then it makes their GFE look more expensive than someone else's GFE. But the fact of the matter is we do disclose it, because there are circumstances when a buyer will end up paying the transfer taxes, and so we disclose them right from the beginning. That way, if during the process of the transaction it changes and the seller won't pay them and the buyer ends up having to pay them, they're already disclosed. Transfer taxes are a zero tolerance area, and a zero tolerance means whatever is disclosed in the beginning, unless a change circumstance occurs, we're obligated to that amount of money. So for example, if the transfer taxes on a particular loan would be $422 and we don't disclose it, only to find out at closing that the seller refuses to pay it, now the buyer has to, then we have to refund that $422 back to the buyer. So in essence, we end up paying for it. If the seller pays for it, it's shown as a credit in the 200 section of the HUD 1. So that's basically how this process will work, is that it'll be disclosed. It should be disclosed. If you're working with a lender that's not disclosing it, that's I can tell you that under the guidelines of what HUD wants with the GFE and HUD 1, that's a pretty big risk that they're taking. Now, most of the time, I will agree the sellers pay the transfer taxes, and I get that. But it doesn't change the fact that the seller is not required under state statute to pay these fees. And that's really what it all boils down to, nothing else. So we disclose it. If transfer taxes are being paid by the seller, there will be a credit on the first page of the HUD 1 in section 200. Do you have one of those HUD 1s? If I can borrow it for a second. I realize that you obviously can't read this, but on the first page, here's your 200 section right in here, and that's where those credits will be shown. So for the buyer, these charges will show up accordingly throughout the HUD, but then what the seller is paying for the buyer will show up in the 200 section, and that's really here, Kim. That's really how that will work out. Okay, so why don't we move to go 2 more slides now, which would be page 12. Now we're going to get into to parts of the HUD 1. Do we have any questions so far? Wow, I must really be explaining this great. No, the next page. When Liz asked me to do this, the fact of the matter is I could put together a 200-page PowerPoint about this, and we've tried to pick up all the highlights and bring it down into really what a 17, 18-page PowerPoint. So we are jumping around a little bit. Again, there is a link that I think Liz is providing that you can download this, read through it, and there's also a place here where you know who to call if you have any questions. So we'll go on talking about the HUD 1 now, and the question being, does conducting a settlement from the definition of title services have the same meaning as conducting a closing? And the short answer to that is yes. They're basically the same thing. Under HUD RESPA guidelines, HUD takes those two definite or terms. They take in conducting a settlement and conducting a closing in HUD's regulations are exactly the same thing as far as they're concerned. If an addendum is used, can the following text be added? See attached addendum for additional information. And you wonder why that's a question. Well, it has come up not necessarily here, but throughout the country, and a lot of addendums are used in various states for various things, and so HUD has allowed for that to take place, and those they're acceptable to insert such a reference where appropriate on the HUD 1. And that was strictly for the purpose of making it clear to the parties what the completed HUD 1 comprises of. So that's the last part I put. How should payments by the seller or real estate agent that are settlement services included on the GFE be shown on the HUD 1? Again, those payments that are going to be provided typically by the seller will be in the Section 200, and seller paid charges will show up in the 500, and so typically your offsetting credits are always going to be in lines 204 to 209, regardless of if they're coming from the lender, if they're coming from say the agent for whatever particular reason, or they're coming from the seller. That's where you're going to find them. Let's go to the next page. What are title services? And this page right here answers that question. So if there's any confusion, just pull out page 13 all the time and you know exactly what we're dealing with. Title services includes any service involving the provision of title insurance, including but not limited to title examination and evaluation, preparation and issuance of commitment, clearance of underwriting objections, preparation and issuance of policy, all processing and administrative services required to perform these functions, and there should be one more, the service of conducting the settlement or the service of conducting a closing. Those are both the same thing. And so if you ever get confused as to what title services are, that's what we're looking at right there. And this is HUD's definition. This is not title insurance. Yes. Preparation of issuance of commitments, clearing underwriting objections, and preparation and issuance of policies. So I believe that would be called abstract and things of that here. Yeah. So that's pretty much the highlights of all the PowerPoints on the, we have some links here. If you're looking for a blank GFE form, you can click on this link and it will take you to HUD's website. You can actually print off the form. It's in a PDF, so you can download it and print it off later. The HUD 1 form is the same thing. You can go to this website and download the HUD 1 PDF and use that. The FAQs, if you really don't have much to do, you can go to this link and download it, and it'll be 63 pages on everything you wanted to know about the new GFE and HUD 1 but was afraid to ask. And it is not the kind of writing that will keep you pinned to your seat. And then, of course, the RESPA link, which is really what this is all, what's prompted all of this. That's the link there, and you can actually go through the entire RESPA guideline and not only read about the new GFE, but read about all the things that can send everyone to jail and what you shouldn't do and how you set these things up. Do we have any questions so far? Wow, I'm really good. Okay, the next thing is again, I just want to remind you, for everyone who's attended, Liz will be emailing this to you, so you will have this PowerPoint, and of course you can certainly email or call me with any questions, and I will do my very best to answer them, or at least cut and paste out of the FAQ where that applies to it. Because of the complex nature of this, the new regulation, there's a lot of information floating around about who does what or what's right or what's wrong. Just give us a call or just send us an email. And if you're not comfortable with asking your loan officer, then ask me. I've been involved in this process since it started way back in 2003, attended the roundtables in 2005, has sat in on many meetings with HUD about the new GFE and HUD 1, and I can tell you that what you're looking at today is not what was recommended by anyone who was involved in this process. What you have is what HUD wanted, and that was pretty much what they did. So they went through 4 years of activities and then just did what they wanted to begin with. So this is the last few pages. Will show you where everyone is located at. It will give you their direct lines and phone numbers, or direct phone numbers and cell numbers. So, feel free to call any of them anytime you have a question, concern, that there's anything that we can do for you. We certainly want to. And, we're here to be of assistance and to help you and to make your transaction, to coin a phrase from HUD, as transparent as possible. And we have, does anyone have a question? No questions at all. Wow. Well, this is a dull topic. I certainly understand that. A lot of information to digest, but just keep in mind that you can certainly contact us anytime, and we'll be. That's it. All right. Well, thank you very much, and everyone have a wonderful afternoon. Thank you.